Drew, we're ready. You want to start recording when we're ready? When you're ready.
Yes, we've just begun live streaming now, so we're on YouTube right now.
Turn on the microphones and the cameras.
I'm not seeing this, so I'm not. On the video.
Unmute.
Oh, they can't hear me.
Yes, that's correct. All right, Attorney Tenorio, can you hear us?
I can hear you now.
All right, let's do this again. I'm sorry. For the record, my name is Jonathan Kwan, Chairman of the Criminal Law Procedure Review Commission. We are here for a plenary meeting of the commission. It is now 12:04 p.m., December 3rd, 2024, and this meeting is called to order. I note for the record that we are in person in the Judge Joaquin V. Manibusan Senior Memorial Courtroom in the Judicial Center. We are on Zoom for those members who are not able to attend in person. We are also live on the Judiciary's YouTube channel. As this meeting is being recorded, to avoid background noise, I ask members appearing by Zoom to please mute yourselves unless you are speaking. And if you are here in person, please wait until you are recognized so we can properly position the microphone. Slide 2 is up. On agenda item 2, due notice. I note for the record that due notice of today's meeting has been provided pursuant to the requirements of the open government law. Copies of the newspaper notices are included in your packet. On agenda item 3, quorum. We'll start with the roll call. Members who are here, when your name is called, please state present and the location you are appearing from. May I ask our CLRC Administrative Assistant, Lisa Ibanez, to please call the roll.
Honorable Jonathan Kwan,
Present, Judiciary Guam.
Honorable Maria T. Senzon. Honorable Anita H. Sepola. Attorney William Bucky Brennan,
Present from Chalampago.
Director of Department of Corrections, Fred Bergalio, or designee Major Anton F. Uggin,
Present, Judiciary Guam.
Chief of Police Stephen Ignacio, or designee Lieutenant Ron Titano. Attorney Joseph B. McDonald,
President of the Judiciary.
Attorney F. Randall Cunliffe,
Present in Tamuning.
Mr. Monty McDowell,
President, Judiciary Guam.
Attorney Stephen Hattori, or designee Attorney John Morrison,
John Morrison's present, Judiciary of Guam.
Attorney General Douglas Moylan, or designee Assistant Attorney General Nathan Tennyson,
President, Judiciary Guam.
Attorney Michael
Present.
Phillips, Ms. Valerie Regis, Attorney Christine Tenorio,
President in Tamuning, Guam.
Attorney Philip Tidingo,
President, Judiciary Guam.
Honorable Maria T. Senzon,
Present, Judiciary.
Sufficient.
sorry, one more time. CLRC Executive Director Serge Kanga,
Present at the judiciary.
Compiler of Laws Jerry Cepeda. President Judiciary Guam. Mr. Chairman, there are 11 commission members present.
Thank you. I ascertain that we have a quorum and can conduct the business of the commission at this meeting. At this point, also, I'd like to recognize a new ex-official member. This is Attorney Zachary Tymon from the Public Defender's Office. Welcome.
Thank you.
And we also have Ms. Valerie Noesa from the Attorney General's Office. Yes, sure.
Welcome, and you're now the AG designee for this?
No, just he's an ex-official,
Okay,
working with DOCO.
okay, welcome. All right, let's move to item agenda number 4, minutes. We have the plenary meeting minutes of September 12th, 2024 for approval. These minutes have been provided in the meeting packets for the members' review. May I have a motion to approve?
Move to be approved as written.
Second,
Second.
any opposed? There being none, it is now been approved. Thank you. Agenda item 5, please put slide 3. May I ask the executive director to provide his status and update and report?
Thank you, Mr. Chairman. This is an informational item that I'm reporting on. You've already welcomed Attorney Zach Timinglo from the Public Defender and Assistant AG Valerie Noesa from the Attorney General's Office. They will be assisting Judge Senzon's DOCO subcommission. And we really appreciate your willingness to help.
Welcome. Thank you.
Welcome. We also want to thank Brian Eggleston on the record for his work on our commission, and especially with the Crim Pro subcommission. He is relocated from my understanding, and we will miss him. I do want to welcome our new administrative assistant, Ms. Lisa Ibanez. She returns to the court after spending many years here working with the Supreme Court and the compiler of laws, brings a wealth of experience, and should be able to help us quite a bit with our work in the CLRC. We also have a new legal researcher, Gordon Anderson. I think he is on Zoom. He was a law clerk and research assistant with the judiciary and has been working on contract for the past few years. I've worked personally with them. I think Judge Senzon has as well. And
As have I.
and so he's well known in the courts, and I think is He's got a good reputation as a real solid legal researcher. So I want to open him up to the chairs. If you have anything that you need to look at in depth, any in terms of case law research, looking at other jurisdictions,
Historical,
please feel free to reach out to me or reach out to Gordon directly. We'll have his contact disseminated to you as well. He's going to be focusing on helping out the DOCO subcommission to help bring them further along in their work. So we'd like to welcome Gordon to the CLRC. Next slide, please, Chair. I have a quick update on the chapters in Title IX. This wasn't in the packet. I apologize for that. We put this together real quick this morning. There are a total of 46 chapters in Title IX that we are looking at, all the chapters in 9. But what you see here are the chapters with the designated subcommissions and the status of each. I know it's difficult to read, but I color-coded it. The green chapters have either been presented and completed or presented and tabled. The yellow chapters have not yet been presented, so they are still pending. So out of 46 chapters, we have only 13 that are pending review. The other chapters have been, the review has begun or has been completed, and I'm talking again about just the first phase. They'll go through the second phase over the next year or so. Well, that's what I have to report on this, Your Honor.
Thank you. Ladies and gentlemen, the reason why we've increased the staff and we now have technical assistance with Mr. Anderson as well as an additional research individual is because we anticipate, and I'm hoping that we get to the meat of Title VIII, which I anticipate is going to generate substantial discussion and work. And if we cannot agree, we cannot agree. That's fine. That means it's a no action, right? But I want to give the subcommission chairs every available tool in order for you to stimulate discussion and get your work done as best you can. So we're making ourselves and the resources available to you as you go forward.
I'm sorry, Mr.
Please.
Chairman, I have one more thing to report. I did request for approval of the work that the attorneys have been putting in for CLE certification. I put that into the Guam Bar in October, and I have followed up with Josh Walsh, and he assures me that they are reviewing it. It's just a matter of time before it's approved. I think the deadline for the submissions of the work that are not
January 1.
automatically included just ended a couple of days ago, or just yesterday, I think. And so the approval should be coming out soon. I'll let you know as soon as that is possible. You should be able to get 2 CLE credits for all the work that you've done over the past year.
Does that include Mr. Tamala?
He just started to.
Did not include Mr. Time and Glow. Thank you.
He gets one for signing up, right?
I'm on the CLE committee, so.
25.
She's the chair of that.
Thank you, Mr. Kenga. All right, let us move to item number 5, subcommission presentations. Please put up slide 5. The subcommission on crimes against persons is first to present. Mr. McDonald, please do so. And I understand there's been lively debate on your subcommission. Go ahead, sir.
Yes, thank you. So this is at the direction of the chairman from last meeting. What we've done is now put the text. We've discussed what I'm about to present to you already. And so I anticipate that we're not going to have much discussion. And I'm just going to go ahead and read into the record the recommended amendments and repeals, of which there will be a few. This is for the 8th. Yeah, so we're gonna just briefly cover the amended and the repealed, and then I'll make a quick note on the second pass. So first up on is chapter 19, assault. And there's a recommendation for parallel and construction purposes to replace the comma in 1950A, replace the semicolon in 1958 with a comma. And this also comes at the recommendation of the compiler, who has indicated that this is the proper way to amend or to fix the statute is by amendment and cannot be done by the compiler's own act. So now is proposed to read 1950 terroristic conduct defined and punished. A person is guilty of terroristic conduct if he threatens to commit any crime of violence with the intent to cause evacuation of a building, place of assembly, strikeout, semicolon, insert comma, or facility of public transportation, or otherwise to cause serious public inconvenience or in reckless disregard of the risk of causing such inconvenience. Shall I ask for motion
We should do it in the end.
At the end.
at the end? Let's go ahead and move then to section 19.81C. The recommendation has been to amend to reduce the offense level for interference with reporting of family violence from a felony of the 3rd degree to a misdemeanor. So that the statute will now read section 19.81 interference with reporting of family violence defined and punished. Subparagraph C, interference with the reporting of family violence is a strikeout felony of the 3rd degree and insert misdemeanor. Moving on to chapter 30. The reason why we're including chapter 30 is to make a parallel edit to section 9 GCA section 1981 just read to the commission. Recommended sections for amendment and appeal. This is coming from a recommendation from the chairman to make consistency in the statutes. So there is now a recommendation to amend 9 GCA section 30.300. And it will now read interference with the reporting of family violence, subparagraph C. Interference with the reporting of family violence is a strikeout felony of the 3rd degree and insert misdemeanor. Any discussion, since there was no discussion on this previously? I hear none. The next chapter is chapter 22. Kidnapping and related offenses. The recommendation is to replace felony with a crime in subsection with crime in subsection A2. So the proposed amendment would then read section 22.20, kidnapping defined and punished, paragraph A2. To facilitate commission of any strikeout felony, insert crime or flight thereafter.
Any discussion?
Any discussion?
Yeah, I hated this one. I was against it, but I felt like it opens up too many possibilities for the offense to be charged, if it's crime versus felony, but that was just my take on it.
I understand. Thank you.
I have a question. What is the advantage?
Precipitated this?
Yeah, what precipitated, what is the advantage of amending it to say crime versus felony?
I'll ask AAG Tenorio to explain.
Yeah, so this was my recommendation. I actually surveyed the different jurisdictions, and there are a few jurisdictions who refer to crime instead of felony. The scenario that came up when we were discussing this amendment is a situation when an individual goes to a bus stop and tries to lure a child into his or her car to commit a crime, but we don't know what it is yet because it's not completed. So for this, we wouldn't be able to charge kidnapping if we were only limited to a felony, because if we're not able to say exactly what felony someone is trying to commit at the bus stop, then we're not able to charge kidnapping. And so this has actually come up in a real life case where, because we're having difficulty saying what felony was intended, then we can't charge kidnapping when clearly somebody was at the bus stop to commit a felony against or commit a crime against a child.
So the underlying crime be charged if this went through would be jurisdiction over adult or
Custodial interference.
custodial interference.
Well,
Yeah.
right,
Correct.
so the way we've been charging it is custodial interference, but even at that, you actually have to interfere. So this is where the attempted custodial interference came from. And so I think that's why that was the discussion, the committee, Mr. Morrison was, I think, suggesting, well, why don't we just still keep it at attempted custodial interference? But I did this based on research in other jurisdictions where they allow for a crime instead of a felony.
It also would apply to family violence cases where person is tending to grab the intimate partner into the car. It's for striking, but not necessarily rising to third degree. I see it.
Right.
I understand you're getting pushed back to the magistrate levels. I see it. Any other discussion?
Thank you.
Yeah, if I might, this is Randy Cunliffe. Well, first of all, you couldn't charge kidnapping in any event because they haven't taken the child anywhere. So that argument is not on point. You could charge attempted kidnapping, but you can't prove that they were going to commit a crime. I mean, at that point, I mean, it's a felony. It becomes difficult, but I mean, it's, you know, if they take the person away, that's a different situation. But if they just make it sit in front of the bus stop and say, "Hey, come here, I give you some candy," they haven't committed a crime at that point. And you know, I agree with John. I mean, I think it just creates more problems than it's worth.
Thank you. Any other discussion?
So just to respond, so in this situation, as long as they're pulling the child into the car, that is the scenario that we're talking about. If you're pulling the child into the car because you're already, you know, taking steps to unlawfully remove them. So whether it's kidnapping, attempted kidnapping, the hold up here at the magistrate level, like Magistrate Kwan said, is not that in the attempt. It is, an attempt is a lesser included offense of a completed crime anyway. So the hold up here is what the actual crime is.
I understand. Any other discussion? All right, we'll address this in the voting at the end of this presentation. Go ahead, please continue.
Okay. The next amendment is to 9 GCA section 25.10. We did have much discussion of this at the last meeting. And it's actually to include a new section, or excuse me, a new subparagraph A12 and 13 in the definitional section found in 2510. So it will now read, if amended, definitions. A, as used in this chapter, subparagraph 12. Affinity means family members related by marriage. The method of computing degrees of affinity is the same method as computing degrees of consanguinity. Sub 13, consanguinity or relationship by blood, paren, quotes, related by blood, close paren, means relationship between persons arising by descent from a common ancestor. I know there's a stray quotation there. Or a relationship by birth rather than marriage, also a stray quotation. I'll read that whole paragraph again. Or excuse me, that whole sentence again. Consanguinity or relationship by blood, paren, related by blood, means relationship between persons arising by descent from a common ancestor or relationship by birth rather than marriage. The degree of consanguinity is determined by counting upward from one of the persons in question to the nearest common ancestor and then down to the other person, calling it 1 degree for each generation in the ascending as well as descending line, such that from a person, first degree consanguinity includes the person's parents and children. Second degree consanguinity includes the person's brothers, sisters, grandchildren, and grandparents. Third degree consanguinity includes the person's great-grandchildren, great-grandparents, uncles, aunts, nieces, and nephews. And fourth degree consanguinity includes the person's great-grandparents, great-grandchildren, great-uncles, great-aunts, first cousins, grandnephews, and grandnieces. If the commission will remember at the last meeting, we proposed a chart. And rather than include a chart, we've just included a narrative of what the lines actually mean per 4 degrees, which is what's in the statute. That's covered for liability, criminal liability. So instead of the chart, we've just simply spelled out what each degree of consanguinity means.
Any comments?
This is Serge, just for clarification. Joe, you want to strike out the straight quotation marks?
The straight quotation mark after ancestor and before by
Okay.
in the first sentence.
Just out of curiosity, was this lifted from any place or was this written out by the committee?
This was lifted from someplace thanks to the research of AAG Tenorio.
Okay, thank you. No, it's clear. It makes sense. Any other discussion? Being none, please proceed.
Thank you. We're now moving on to chapter 25A, solicitation of children and child pornography. Just as an explanation before I read the strikeouts, each section had an exception to a defense for solicitation and child pornography. And rather than have it be in each section, the recommendation was to have a new section to encapsulate all the, just to have it apply to the article. Okay, so the first is to amend section 25A 102C, indecent electronic display to a child, by striking the entirety of paragraph C. And that paragraph, it shall not, or would read if, would not read if, well, it reads now, but would be struck. It shall not constitute a defense against any charge of or violation of this section that a law enforcement officer, peace officer, or other person working at the direction of law enforcement was involved in the detection or investigation of the violation of this section. The recommendation is to strike that language. 25A 103. Amend by striking A1B and subsection D. 25A 103, electronic enticement of a child is a 3rd-degree felony. Any person who, using a computer online service, internet service, or any other device capable of electronic data storage or transmission to solicit, lure, or entice, or attempt to solicit, lure, or entice. 1, intentionally or knowingly communicates, and the recommendation is to strike subparagraph 1B. With another person in reckless disregard of that risk that the other person is under the age of 18 years and the other person is under the age of 18 years, striking that. And now making what would be subparagraph 1C as 1D, and striking the entirety of D. It shall not constitute a defense against any charge or violation of this section that a law enforcement officer, peace officer, or other person working at the direction of law enforcement was involved in detection or investigation of a violation of this section. Okay. Moving on to section 25A 104. Also to amend by striking subsection A1B. The amendment now would strike out 25A 104, electronic enticement of the child as a 2nd-degree felony, and striking out 1B, A1B, with another person in reckless disregard of the risk that the other person is under the age of 18 years, and the other person is under the age of 18 years, or, and striking that entire paragraph. That's paragraph. 25A
I'm
105.
sorry, back up. Did you have to renumber? You have to renumber subparagraph C to become B. Housekeeping detail.
Okay,
So 25A 104 reads A1 subparagraph A, subparagraph B, subparagraph C. You're striking subparagraph B, right?
and yes,
Then so subparagraph C must become B. Just put a note.
that's correct.
Thank you. Please continue.
Okay. Now moving on to 25A 105. As with the previous sections, striking A1B. And so the language on 25A 105, A1B to be struck with another person in reckless disregard of the risk that the other person is under the age of 18 years and the other person is under the age of 18 years, or and making just to complete the edits and making paragraph C now subparagraph B. Okay. 25A 106, which is adding a new section. This is a proposed 25A 106. And this is to apply to all of the other previous sections in the chapter. So the new section now would read 25A 106, electronic enticement, no defense. It shall not constitute a defense against any charge or violation of this section that a law enforcement officer, peace officer, or other person working at the direction of law enforcement was involved in the detection, or I think this is a mistake. It should not be section, but it should be chapter.
Captain,
It says chapter.
all the other provisions, you've lifted it out of individual provisions and made a kind of a global.
Yeah, so it says right here, if you read that,
It's got to say this chapter. right?
yeah, this chapter as opposed to
The second line.
violation of this
Second
chapter.
line,
That's correct.
yes.
Okay, so I will read it with its correction that we're making now. It shall not constitute a defense against any charge or violation of this chapter that a law enforcement officer, peace officer, or other person working at the direction of law enforcement was involved in the detection or investigation of a violation of this chapter.
Any discussions? There being none, go ahead.
Okay. Chapter 26, Human Trafficking and Criminal Exploitation Act. This brought much discussion at the subcommission level. And the proposal is actually just to repeal Article 2 in its entirety. And just to cut to the chase, there are provisions in there that just aren't really being enforced or funded in any way. And at any rate, we do see that the feds are very active in this area.
And that training obligation and other things that were required to be done if the statute stands.
Right, and the task force.
Any discussion on that?
Is the AG's office okay with that?
Mr. Tennyson? Ms. Melissa?
I would need a little more time to review and to come up with a determination on that. Because I haven't looked at chapter 26 or article 2 in these subsections, and this is the first I'm kind of aware of it. If it would be possible to table this so that we can take a closer look. You know, just this particular one. I don't know what the procedure plan for going forward is, but I would need a little time just to review. I can't speak off the top of my mind on it.
I raised it because I recalled that
That
this
money.
was an AG generated legislation.
Mhm.
And I just wanted to make sure that the AGs, it's from back in the day, but
I mean, to our knowledge, they'd never charged any crime under this chapter. Was Blue House?
yeah, I think it generated
I think that was
either
just
out of
straight up
Blue House.
CSC stuff.
This came
right?
out after Blue House.
Yeah, this came
Because
out
of Blue
after.
House.
It was a response to the
Yeah.
Blue House, because we were
Statutory.
restricted by the types of offenses we could charge at that time. Remember, that was a complex case because the US Attorney's Office cherry picked, went after Mama San, but didn't go after the police
We all
who
remember.
were involved. So,
months of my
you
life,
know,
just like everybody.
I'm old guy, I can say whatever. So, you know. So
We were there, we were
We
all
looked at
there.
we were there, you know, so, I mean, we were shocked that why are we left having to do this when it should have been done federally? That's why, to say that the feds do it, well, they cherry pick, so. That's why I wanted to make sure that the AG's office is okay with that.
Can I also raise the issue that I think the Coalition Against Domestic Violence and Sexual Assault also had federal funding that they were supposed to work with the Office of the Attorney
Yeah.
General
Right.
on this human trafficking issue. And so I don't know if anything ever came of that with the AG's office, but I think there's already federal funding that was
Made
given.
available.
Yeah, that's right. And so I don't know. I think it's a good idea to have Mr. Tennyson take a look at that.
An
at the
objection
AG's
to-
office.
Any objections to tabling this?
Back when Alicia Limchak was the U.S. attorney, she was big on this. She had a committee. I was on the committee. She brought guest speakers to town. Went with her on the radio to various organizations. We spoke about human trafficking. I assume it's still got the comment that Attorney McDonald made was correct. This is really big in the U.S. attorney world. Doesn't mean it shouldn't also remain here or not remain here.
Yeah, I took a look at the sections, and there's quite a bit of intersection between federal and local issues. I would request if we could have just a little time to dig in on our side and just so I can come back with something official, and we can have that by the next meeting easily.
Any objection to tabling this? Objection being none. Okay, this is tabled.
Yeah. Can I
Thank
also
you.
add just one more thing? I did a workshop with the National Council on Family Judges, and we talked about an issue about human trafficking related to intimate partner violence. And especially where there's an individual a victim who is also awaiting, has a different immigration status, and how that also comes in a domestic violence case. So it might not be human trafficking per se. Yeah, but then, there's an issue because then they're trafficking the spouse or the victim using this. And so what did come out of that was a certain visa, right? And so I don't know if also the AG's office might be working on something related to this emergency visa for these individuals. So, I think it's a kind of important because it does possibly eke in from a domestic violence or family violence type case and possibly into chapter 26. Again, I don't know.
I think it's a good point that the judge brings up, because I recall the U.S. Attorney's Office contacting us, and we had to endorse the T visa application. In other words, were we also investigating conjointly, and that allowed some of their victims to get the T visa. And I remember endorsing that when I was either the CDAG or the chief prosecutor. So again, I just want to make sure the AG is okay with repealing all or part of it or whatever. Okay.
May I just say something? Oh, by the way, I'm not authorized to speak. I'm here as a general member of the public. Okay, so just General Christine Tenorio, attorney. So if you'll look, it was only Article 2 that was suggested to be repealed, not Article 1. And the reason for that is basically all the organizations involved are in violation of the article. Like, I know that this came out of Blue House. I was around, but it's basically defunct. And so we didn't want anyone to be held liable for any, lack of participation or fruition of this campaign. So even though you would strike Article 2, all the crimes available in Article 1 are still available as charged, although we actually did have extensive discussion on what qualifies as commercial sex act, because quite honestly, as it's written, it's not chargeable right now. So we would have to delve into Article 1 and the definitions given as far as how we can charge human trafficking. We had an extensive discussions about this, because right now, the way we would charge this is we're just going to use just criminal sexual conduct, the regular criminal sexual conduct offenses, just because it's easier to prove. So that's how this came up. Thank you.
Okay, this is tabled. Thank you.
Mr. Chair, can I make a recommendation
Please.
or a suggestion to the subcommission chairs? If there is discussion in your subcommission on a particular section or chapter or article like this Article 2, you're free to reach out to any other member of the commission to ask for their input. I think that's why these plenary meetings are very, very helpful, because everybody's here sitting down and we're a captive audience to the recommendations that you're making. But at the subcommission working session level, you should feel free to be able to reach out to other members who are not in your subcommission, asking them for their input if you think that they have they can make some good substantive comment or input on whatever issue you're working on. And we can help facilitate that if you get a hold of me. Thank you, Mr. Chair.
Thank you. Please proceed, Mr. Miller.
Okay. Moving on to 9 GCA 26.41A. Recommendation is amend the statute to get rid of maliciously, which is not in the MPC, the Model Penal Code. Any person who maliciously strike out maliciously or with criminal negligence publishes, disseminates, or otherwise discloses the location of trafficking victim, any trafficking shelter or domestic violence shelter, or any place designated as a trafficking shelter or domestic violence shelter without authorization of that trafficking victim, trafficking shelter, or domestic violence shelter is guilty of a misdemeanor. I do know that we actually had, I believe, knowingly, any person who knowingly was originally proposed. However, criminal negligence being the default, the mental state would also cover any intent or purposefulness. So it still reads the same logically and structurally, even without, even without the higher mental state.
Any discussions?
To be clear, so if I do something with criminal negligence, that can include malicious intent?
There is no maliciousness in the Model Penal Code.
MPC.
Oh, I see. Okay, I understand.
So it creates issues, especially when it comes time to charging
Mhm.
and charging. And then since you already have criminal negligence as the default in any MPC statute, any higher mental state or would be encompassed in criminal negligence.
Title 9 GCA section 4.30 lists out the levels. So
Okay, so this is conforming with the MPC.
yes.
Okay, sorry, I thought we were diverging. Never mind, I withdraw my question.
Okay.
Any further discussions on this? Okay, please go on.
Okay. We're now moving on to chapter 31, offenses against the family. Section 31.30. Recommendation is to amend by adding new provisions. And this came also after a great deal of discussion. Amend section 31.30A to now read, a person is guilty of child abuse when 1, he subjects a child to cruel mistreatment, or a new subparagraph 2 inserting willfully causes or permits any child to suffer. Subparagraph 3 inflicts upon a child unjustifiable physical pain or mental suffering, or, and then renumbering what used to be 2 to 4. Having a child in his care or custody or under his control, he, A, deserts that child with intent to abandon him, striking subparagraph B, subjects that child to cruel mistreatment, or, and now making what was subparagraph C, subparagraph B, unreasonably causes or permits the physical or emotional health of that child to be endangered, and inserting through amendment, or unreasonably causes or permits that child to be placed in a situation where his or her person or health may be endangered, or, and now reading subparagraph AC, A1C, neglects that child. That was a mouthful. Any discussion?
I have a
Yes.
question.
Go ahead. Please, Mr. Tate.
Willfully is not MPC language.
Yeah.
What would we want to be consistent?
We do, I think we would just sub that in for intentionally. So just for background, Section 2 and 3 came from California Penal Code Section 273A, which is what our actual original statute, it was modeled after that statute, Cal Penal Code. And then subsection C also came from New Jersey, which is also the statute that we modeled the code after. So I was trying to, in researching this, I was trying to expand it because when you read the current child abuse statute, it's actually really hard to prove. And so child abuse right now just kind of gets swept away within family violence. Like they're just merged together and it's not really paid attention to, but I also think it's because the language is very limiting as it stands.
Okay,
have a-
so, sorry,
Please go ahead, Mr. Cunliffe, or is it Mr. Tennyson?
Tennyson.
Mr. Tennyson, go ahead.
Nathan, I have a question. For subsection A2, is there a limiter on suffer? I mean, I know what we mean by suffer, but is there a definition for that, or I mean, you know, where's the boundary between criminal suffer and maybe something the child doesn't like, you know, a punishment or something that they say suffer?
I have the same concerns with A subsection 2. I find it too broad, because under 9 GCA section 7.94, spanking is specifically allowed, physical pain is specifically allowed. So technically, that would, subsection A2 would bump up against 7.94. Physical disciplining of a child is allowed under 7.94. But 2 would cause a problem with that. Now, I note 3, subsection 3 allows for justifiable physical pain, which would be spanking, but 2 would prohibit it.
And there's also a little bit of not maybe a vagueness issue, but I think a little more specificity could help with getting the intent of that subsection across, without maybe some broadness that is uncertain.
I understand what everyone's saying. I think the issue is that California Penal Code didn't define it. And the way it's defined right now is when they give jury instructions, they put inflicted pain or mental suffering so that the defendant inflicted unjustifiable physical pain or mental suffering on a child. So suffer is actually not defined as everyone's saying. So I understand. I was just giving options so we can see what the California jurisdiction is doing.
Would a justifiable standard help? I mean, I think 3 works because you know, there's a justifiability issue in there. You know, willfully causes or permits any child to unjustifiably suffer. I mean, I don't know. It could be, there has to be a word or something that would.
Unless there's any objection, especially with Mr. Nori, I think, who was working on this one. I think the purposes of the subcommission be satisfied if you take out strike subsection and line 2, because you still get everything else.
Is the intent to be like, that's the person who doesn't act when they're supposed to act? Or the other 2, 1 and 3 are active verbs?
Right.
Right.
Right. I think the way that it was modeled when California does it, they actually were differentiating between intentionally and negligently. So that's why the sub 2 and sub 3 look different. But I do agree, if you take out subsection 2, it could still be subsumed by the other subsections.
I think it's covered.
Or else you have to put a modifier like unreasonable or unjustified.
Again, yeah, but then you're repeating 3.
You're
so-
repeating 3, right?
Yep.
And everything,
I think the intent on 2 was to create an intentional mental state as opposed to a
I
reckless.
think so too. I think the willfulness was supposed to be an intentional.
but the problem everybody's having is the definition of suffer.
It's the word suffer.
Yeah.
Right. That's broad, right?
Okay, so we'll just,
Any objection to removing 2? I think without 2, it'll pass.
any objection to striking 2?
No,
There's none.
No.
No objections. So,
Mr. Norio?
Mr.
No
Nori,
objection. No objection.
so
Striking 2. Now it'll just read A1 and 2 and 3.
no, just 3.
No, instead of 4, that'll be just
Oh, I
1, 2,
apologize.
Yeah, there's a
You're
4
right,
now.
sorry. That's correct.
We'll renumber it appropriately.
Okay,
Sorry, Mr. Chair, I think Attorney Simon might have.
No, the question I was gonna raise has been raised.
Oh, okay.
all right, so no objections with the striking of the proposed 2, it'll move forward.
Okay.
Okay, thank you. Let's continue. Good work, Mr. Scenario. Thank you for the efforts on that one.
Thank you.
Okay, we're still in 31. And we're now looking at adding a new section 31B. And just even looking at this, instead of willfully, we're gonna make it intentionally. So now it will read. As used in this section, neglect of a child shall consist in any of the following acts by anyone having the custody or control of the child. D1, intentionally failing to provide proper and sufficient food, clothing, maintenance, regular school education as required by law, medical attendance or surgical treatment, and a clean and proper home, or sub 2, failure to do or permit to be done any act necessary for the child's physical or moral well-being. This is to define neglect of a child.
That came directly out of the New Jersey statute.
And then we're replacing again willfully with intentionally.
Two ways to commit,
That's correct.
either 1 or 2.
Willfully, intentionally failing or failing to do or permit a necessary act.
Can we make it consist of any rather than in any? In
Where are
the
you?
first line?
Consist of any of the following,
Yes.
of any,
Neglect of a child shall consist
of any
of any.
of the following, okay.
And 2 is the omission.
Who did the work on this one?
Scenario.
Sonori, did you see any? You might not have touched it, but did you see any issues with Jehovah Witnesses? On this?
That I actually did, and so it doesn't prevent them from putting forth the defense. So they're still able to use that as like a legal justification. That's all I saw on that issue.
And so it is addressed, that's fine, I got it,
So there's sufficient case law to deal
Yeah.
with it.
I'll have to use Jersey. Any discussions on this? There being none, all right, I believe that goes forward.
Okay. And then just that concludes all of our recommended appeals and amendments, repeals and amendments. And now sections under second pass are the ones enlisted on the presentation. I'm not going to go into each of them, but these are the ones second and pass. Chapter 93, chapter 89, chapter 31, chapter 25A, chapter 22, and chapter 19.
These passed the last time, right? This went through?
No, these are second pass, and we're gonna,
Right.
we're actually, when we did the first reading.
Yeah.
The issues came out and there was no resolution,
Right.
and what we wanted to do was report out everything that would easily were low hanging
Right.
fruit. So these are the ones that are a little higher up on the tree.
And there was no additional issues with this.
No, these are going back under the lens.
I see.
For even more discussion. This is what I was talking about having a time limit for the members of the subcommission to actually put any comments or recommended edits.
Okay,
to the staff.
I understand.
These cause the most
I see.
discussion.
Okay. We will set, the executive director will set a deadline to your subcommission as to when it's either make a decision or.
Official cut date.
That's correct. Okay, there's no further discussions. I guess we gotta go back and vote. December 31st, 2024. Okay. I'm gonna try to do this in bunches here, okay, because I know which ones we are having an issue with. So, on the table for approval to move to the final reading file. Title 9 GCA section 1958. Please write this down. Title 9 GCA Section 1981C. Title 9 GCA Section. Well, at this point, any 1981C, I apologize. Title 9 GCA Section 2510. Title 9 GCA Section 25102, 103, 104, 105, and 106. I'm going to ask that there be a motion to move this to the final reading file. As I recall, there was no arguments on any of these issues.
I move.
Second? Any objection?
Mr. Chair, there were some corrections.
I don't remember the section that we were discussing. It had to do with removing
Yes.
somebody for a felony versus
Yes.
a crime.
That was
And I object to that change.
2220, we haven't done it yet. I omitted that, that's 2220. So that's not on the table right now.
Okay,
No, it's not on the table right now.
Not on the table.
Okay, so any objections
Remove this
with,
secondary.
to move to the second file with revisions that were suggested by the subcommission? Being objection, all right, let us move on to the section that was giving us a problem, which was, I believe it was 2220. Title 96 CA Section 2220. That is specifically the kidnapping section, and specifically the change from the word striking felony to crime. There was some objection on the floor on that issue, specifically 8.2. I'm going to call for a vote at this point.
May I make a quick comment on this, just because I didn't before and I needed some time to think about it.
Yes.
So this one is interesting because, so the best example I have is there was a suggestion to amend the, it's no longer, not a third-degree felony to interfere with reporting domestic violence. I think it's a misdemeanor.
Right.
So let's say I kidnap someone to prevent them from reporting that. If it's a felony, it can be charged as kidnapping, but if it's a misdemeanor, it's no longer chargeable unless it's also a crime. So what we're looking at here is a small subsection of things that aren't quite felonies, but that you could use kidnapping to effectuate, and should kidnapping still be chargeable for those kinds of crimes. And I think the example there is reporting. If it's a felony, kidnapping applies. If it's a misdemeanor, it doesn't. And that's my perspective on it, and I would be in favor, but nothing further. Thank you.
I understand. Thank you. Any other further discussion? Mr. Cunliffe's objection is noted, as is Mr. Morrison's objection on this issue. All right, I'm going to call for a vote. At this point, is there arguments notwithstanding? Is there a motion to have this section 2220 moved to the final reading file?
I so move.
Is there a second?
Second.
Is there an objection? All who object to moving this, please indicate nay at this time.
Randy Cunliffe, I object.
Nay, John Morrison.
Anybody else?
Nay, William Brennan.
3. Okay, ex officio, thank you though. 3, all right, at this point, Mr. Director, my understanding, 3 does not carry, not enough.
If we could.
Given the current quorum, it does not block it. All right, over the objections of the 3, this matter is moved, this particular section is moved to, 2220 is moved to the final reading file. Thank you. I appreciate the discussion, everyone. All right, and the final issue was that we have to cover is human trafficking, is that correct? That is the removal of Title 9 GCA Section 2620, 2624. That has been tabled, if I recall correctly.
Yes.
And let us move to, there's only 3 more left. 9 GCA Section 2641, which is removal of the word maliciously in 2641. Additionally, Title 9 GCA Section 3130, with the only suggested additional revision is to strike willfully causes or permits any child to suffer. Okay. And then finally, 9 GCA Section 3130. Any objections? Sorry, is there a motion to move those three statutes to the final reading file? Any second? Okay. Any objection? There being none, those three statutes are moved to the final reading file. Mr. Magano, thank you very much for the work of your subcommission on this.
Thank you, Mr. Chair.
All right, let's proceed. All right. Next up is Judge Senzon and the Drugs and Other Criminal Offenses Subcommission. Madam Chair, please, Madam Chair, Mr. Judge Senzon, please go forward.
Thank you, Your Honor. Well, this is gonna be a short report because, at the last meeting, it was just myself, the compiler of laws, the Superdayo, and, retired Judge Barrett Anderson, who were in attendance, and that's why I asked for, the appointment. Thank you for Zach Tamanlo from Public Defender and, Assistant AG Valerie Nuesa to assist as well from the Office of the Attorney General. We started with the Uniform Controlled Substances Act. Again, just a review of the provision. It's quite a long chapter. We are, thank you. Thank you. The adult drug court judges, myself and Judge Tolentino are already engaged in doing internal adult drug court revisions, but because the DOCO is going, or is also looking at the statutory changes. Article 1, starting there with the definitions, no changes were recommended by those of us in attendance on the committee. With respect to Article 2, however, standards and schedules, and Article 3, the regulation of manufacture, distribution, dispensing of controlled substances. It was discussed and agreed upon by all of us that we are not experts in this field, and we do require the expertise of individuals who are part of the Department of Public Health and Social Services to review. So I'm going to request Director Therese Ariola, if she can have someone designated to assist the subcommission to help us to identify whether or not any amendments need to be made to these particular identification of the substances. So that is where we are right now for Article 2. For Article 4, the offenses and penalties, and that's why I actually did want to have the assistance of someone from the defense bar as well as from prosecution with respect to the offenses and penalties. Right now, thing that is most prominent, I think, during our adult drug court hearings is the fines. Fines and things that go into whether or not they are convertible to community service. Right now, the statute appears to provide it only if read in conjunction with another statute that talks about a defendant's ability to pay for fines and court costs. So there's nothing within the statute itself, and how it's been interpreted is that the remaining portion of, say, $500 if you're an ADC 1 or $750 or more if you're an adult drug court 2, those could not be converted to community service. But the problem is that we're seeing a lot of the individuals who go through the whole program very successfully and can't pay that final amount. Right? So it's been kind of the sticking point with a lot of the successes were. So we send them to collections court, and even though they might be successful,
Thank you, by the way.
yeah, if they're, or, I mean, of late, there have been several motions to review these outstanding fines or the balances because under the other statute. So there have to be a finding and things of that nature. So, and that's only a very small portion of on the offenses and penalties, but I think that we do need to have the input from the defense bar and prosecution, specifically with regard to offenses and penalties, because right now our commission does not have anyone other than Attorney Mike Phillips, who's part of the defense bar. Yeah, so that's my subcommission's report.
I have a question. Given that your expertise is on the back end of this in terms of the pleas and what happens next and the probationary periods, mine is not mine in the front. Would you be in favor, I'm just talking out loud, would you be in favor of a general statute, one that would apply to all the code, 8 and 9, or 9 specifically, that would allow the conversion upon the specific order of the judge on all types?
Just generally in fines. I mean, I think there is one that, requires us to review whether a defendant has the ability to.
No, but even, I'm
payments, but-
talking just, you can, at that point, for all cases, all types to say, okay, you know what, I'm making a determination.
Well, as a judicial officer, I love anytime I'm given discretion to do something based upon a particular set of facts or circumstances, but, I mean, I do think that that would be an important part of, an individual, or just cases in general, like if every case has an attached fine plus court cost to it.
Because of the mandatory, these statutes that I'm seeing, especially that affect your cases, there's a mandatory fine by the legislature. If we have a subsequent statute later in time that is specific to the powers of the judicial officer saying, notwithstanding any other provision of law, a judge, after a finding, may find that the fine, mandatory fine is maybe waived in favor of community service. I mean, you can.
I mean, I'd have to probably think about that. I mean, like I said, I think generally when you give the court discretion to do what it needs to do, or, based upon a certain set of circumstances, that's always favorable in the eyes of the judge or the court. But, I mean, I'd have to think about it.
I'd ask you to consider it, because that would alleviate some of your issue. But I'll leave that. Any,
Is that-
Comment, because, somebody who's been involved with the therapeutic courts since the inception of 2002. You're seeing people who prior to 2002 and implementation, they just went to DOC. We just threw away the key for a certain amount of time, no rehabilitation, nothing. And so with the juvenile drug court, the adult drug court, family treatment court, veteran treatment court, and so on, we now have these vehicles where we take these people who are gonna be somewhat of a scourge to our community, and we go through an intense, what these judges and their staff do is take a person and completely strip them down and build them right back up in a 1 to 2 year process. And in the DUI court, it can sometimes even longer. And to have this inability to say, well, you have a $700 fine or some amount of community service, pick whichever one works, but you don't have that latitude. So they've gone through this excruciating process and been drug tested at work, at school, and they've made all their commitments and whatever. And now they reach graduation day, but they don't have the money to pay their fine, so you don't graduate. That's ludicrous.
I think, because of the language that, the $5,000 of the fine can be converted to community service, except for
yes.
500 or 750. For what purpose, I guess?
What's the policy
What's the
for
policy?
having a minimum
I'm in agreement.
mandatory,
Yeah.
amount on the fine? In other jurisdictions, I know the discretion to convert is part of the general punishment scheme anyway. Because why would we want to hold up everything? I mean, statistically, I'm pretty sure we could all agree that that tends to be the folks that can't afford, that are in our system, the fines that are like that. So why hold them up? Especially if we want them to be gainfully employed
Because here's the
on the
problem.
way out.
Once she has to close the case and make the right decision, closing the case, without the fine being paid, it cannot be converted. It then gets sent to restitution court, which I don't have the power to impose that conversion. At that point, it's too late. The only thing I can do on a defendant who has a fine that is mandatory, I can only hold up contempt for non-compliance. I don't have the ability to convert it. So I have these.
Right, so you put him in jail for 10 days, loses his job.
Right,
for the
exactly, and I'm not
restitution.
gonna do that.
That makes
So,
no sense.
Is it possible to zap their tax returns?
Assuming they're.
Assuming they're-
Yeah.
Oh, we just talked about
If
the
they have-
situation that they were working, right?
Yeah, you got it, yeah.
The bulk of
Anyway,
them are barely surviving. on what
But
they
I'm
have.
saying other places, they don't have that minimum mandatory restrictions with that. I don't think
Well, and
jurisdictions.
a lot of other jurisdictions have the benefit of SSI or some other.
Yeah,
federal-
right, that's true too. They have other,
Federal program.
By the time I get them, I can't do anything. I mean, I can put the feet to the fire, but I don't want to
So-
put them in jail.
Other jurisdictions, like for example, we went to Collier County and we visited their program. They have, for example, 26 active cases versus 100, almost 200 active ABC cases that we have between myself and Judge Tolentino. And then there is a component that participants in Collier County, which is the model treatment court, where they or their insurance company pays the remainder of the fine. That's their, their fine because it's treatment. It goes back into a pot for treatment for everybody else. But like I said, we don't have the same kind of coverage, insurance coverage, or like you asked a participant, do you have insurance coverage?
No.
I mean, I don't know if our insurance coverage would cover something like that, right? We're lucky that we get a little bit of a massage once a month for whatever it is,
12
but,
here.
but, so that is a problem, and I know that on the, what the amount of money is being used for is to provide that treatment or, compliance, equipment like drug tests and, even, when we have incentives, it goes to buy incentives for our participants. And frankly, right now, we're full on out of any funding for that, so it's important part, but at the same time, I had 3 or 4 who I just had to issue decisions on where it had to go back to a change in circumstances under a different statute where I was able to say, we're not gonna require the remaining balance to be paid off before you graduate.
Out of curiosity, did you close it and then send it to resolution?
I
court,
did not.
Or did it die?
No, it was a decision in order
To
relieving
just-
them from that obligation.
I understand.
Yeah.
Yeah.
Based upon a different statute, not something within the Uniform Controlled Substances Act.
Okay.
So,
Well, appreciate the update on Doko's position. You now have 2 ex officio that have been appointed, plus don't forget you have Gordon Anderson now.
yes, thank you. And kind of related to that, and I think, I'm sorry, I think it was Judge Ficola's subcommission that's dealing with the defense. And so you mentioned Gordon. I'm also assisting Justice Merriman and Judge Barcinas in revamping our mental health court programs. And so with respect to the defense sections, Gordon has been assisting the internal committee as well. So we do have some additional comments that we're going to provide you with respect to the sections on defense, particularly the NGRI defense, and how it goes through the system because of the lack of psychiatrists. Yeah. And again, Dr. Rapadas is also thinking about retiring. Yeah. No matter how much we want to apply that section on kidnapping to him. We want to keep him to be able to do our forensic evaluations and just, as another point of information, Dr. Rapadas does about 120 forensic evaluations a year. And not in maybe 1% of those individuals go into mental health care. So we're looking at a population, criminogenic population that has sometimes severe mental illness that don't qualify for mental health court. So that's another issue I think that UC Director Verdallo is also dealing with within his population.
All right, thank you for the update. We'll look forward to your further work on this and we'll come on your commission.
Thanks for the additional.
Okay, at this point, I believe the next,
Do we want to, I'm sorry, take the recommendation to approve the definitions with no changes?
yes, any motions?
So move.
Second,
Second.
any objections to the approval of the definitions with no changes that have been recommended? There being no objections, it's moved to the final reading file. Thank you. All right, Attorney Tidinko, in terms of the status update on the property subcommission.
Yeah, I'm gonna have, I think Bucky's on the line. I think Bucky put this together. So Bucky, if you could take us through this. You still there?
Yes, sorry. I am nursing a sick baby. I'm on leave.
Oh,
Sorry,
okay.
guys. So no, I don't know how long he'll cooperate.
Sorry.
Sorry.
Let's get to the next slide and see, but please jump in. So this just shows what we've completed in terms of our review, although I was just informed recently that we did not do chapter 13, or that's being reassigned or has always been assigned to us. For some reason, I didn't think it was. So we still have a outstanding chapter 13, which is the inchoate crimes, attempt, solicitation, and conspiracy. And so we may be making a request that some legal assistance to review the Guam Supreme Court case law on any of these statutes.
You can do that.
Yeah, we need that because I think there has been some challenges on some of those. So But yeah, that's what we've gotten through, but and now until we have 13 to get to, so.
Well, 13
Is
is
there
gonna
any-
cause a lot of discussion with you.
And they'll cause a lot of discussion. Is there any other chapter that we've overlooked, Serge?
I think that was it.
Just in
We'll
13?
work with Gordon on that.
Okay, great, because that would be really helpful. We had a summary of any of the Supreme Court or even Superior Court cases that have issued decisions on the chapter of an attempt, solicitation, and conspiracy. Okay, next slide, please. Okay, our items for today is our chapter 69. And that's the antitrust law. And then chapter 60, the 10, that's firearms. Next slide. So to clean up, which we have proposed in other statutes in terms of the penalty language, is just to simply just state it as a guilty of a felony in the second, and not add all the rest of the language. So we proposed repealing the rest of the strikeouts that you see there for violating the antitrust law, that it would be a felony in the second degree. So, and then you just need to consult the general imprisonment statutes to see what and penalties for felony second. Okay, and then the next slide. Oh, by the way, any discussions on that? Any issues?
Why are we reducing the statute of limitation? Just to make it,
Which one are we on?
can we go back?
Go back.
I made for a second, just for the record, Attorney Morrison from the Public Defender's Office is stepping out, so we still have a quorum, correct? 10. Please proceed, thank you.
You know, I think because we have the general statute of limitations or time limitations chapter should cover it, so. Yeah, it's 3 years for felony, so we weren't feeling comfortable with this difference, keep it consistent. Unless there was a policy reason for why we needed a longer, I mean, in some jurisdictions, what I call financial or paper type criminal offenses, statute of limitations are longer because of the difficulty of uncovering it and getting the evidence, but we just wanted to be consistent with our time limitation statute, which is 3 years for felony. And then the only other exceptions, right, are rape and murder, right?
Right.
So that was part of that.
And official misconduct.
And official misconduct, right?
This is just for antitrust,
Just for antitrust, yeah, just for this chapter, basically.
which has never been charged.
Which is never.
This is
Yeah, this was a.
Now it's gonna get harder.
Yeah. Well, you got 3 years to figure out the antitrust crime there, yeah?
No.
Okay.
Any discussion?
Any discussions on the repeal of or strike out of that language, the provisions there? Okay, next slide.
She has
So-
Sorry again.
Okay.
Go back.
Go
again.
back.
Sorry.
This is the white collar guy talking, that's why.
So we're actually now also saying, however, that even if you've been convicted in federal court, you can be charged in local.
Well, there's always been that sovereignty type issue.
Well, this made it express, right?
Right. I mean,
Okay. I just wanted to note for the record that the recommendation is also actually now to remove the double jeopardy based on jurisdiction.
right,
That's right.
right.
Hey, this is Bucky. Yeah, sorry, this is Bucky. I think removing section B is consistent with the Sanchez Valle case for Puerto Rico. And that already puts to rest the sovereignty issue that Phil is alluding to.
Right.
Yeah, this is Randy. Also, I mean, our code says if you're convicted in federal court, you can't be convicted in the Superior Court. And the federal law says if you're convicted in the Superior Court, you can't be convicted in federal court. So it's just restating the law that already exists.
Unstating it.
Unstating, anyway.
Unstating surplus.
No, it's stated in the code earlier that says that, you can't be convicted both in federal court and in the Guam courts.
Right, right. We're just being consistent.
Of the same act.
Yeah,
Yeah.
Yeah,
we're just being consistent. Okay,
Okay.
okay,
it's redundant here.
Got
yes,
it.
yes.
Any other discussion? Good, thank you. Next.
Okay, and let's see, these are the provisions for the injunctive. We recommended this provision should be placed elsewhere in the civil code. Apparently we've come across this in certain offenses where they put language that pertains to the civil lawsuit side of the particular crime, so we thought it should be placed elsewhere.
Okay.
That's our recommendation. If there's, because this language permits a civil lawsuit by the AGs for antitrust violations, and we thought it belongs somewhere else, not in the criminal code, but that's the recommendation.
Any discussions on this?
What-
Sure.
Yes,
Where would it,
I don't know.
because I don't think there is a sort of a tort cause of action or.
Well, and it needs to go
Or
into
they need
section
to make a
44.
section then.
What I could do is I could work with the compiler to find the appropriate place for the civil code. And we can report back to the,
Yeah, isn't there in Title 7, some chapters about the different kinds of torts or causes or whatever of action? I can't recall.
This
No,
would
I
be,
guess-
this would actually go into one of the business sections, business regulation.
Business reg, right, you're right.
Essentially, yeah.
so
11,
are you
maybe 11, the
volunteering
tax
to?
code. Part of the tax code, right?
After what he did earlier, no?
Part of the tax code, right? Yeah, yeah.
We'll look,
This would be in the business regs.
and we'll propose the appropriate amendment.
That makes sense.
And there's actually, I'm sorry, there's actually, the consumer council type statutes where this might.
Right. Anyway, we recommend that it be placed elsewhere outside of the criminal code, 69. Okay, next slide, unless there's further discussion.
Okay, so any further discussions on moving, not repealing, just moving these sections to another non-criminal area? Any discussion? There being none, please proceed. Go ahead.
Okay, is this the next slide?
Yes, fire.
Okay, so we're into firearms here, and what we've done is we've added to an amendment that would add or who enter the United States. Gosh, I can't barely read.
Pursuant to an applicable compact.
Compact, oh yeah, to try to cover COFA in here, yeah. And then proof of entrance of COFA shall be evidenced by either these two types of, by a completed CBP form or a copy of the notation made upon the migrant's passport. I wonder if that's the proper word, migrant, should it be?
It's migrant.
Is it migrant? Is that the proper word?
So specifically now, this is prohibiting.
For where, as it concerns aliens, and I think Bucky researched the case law on this, I can't recall. If you're listening, Bucky,
Yeah, no, it wasn't a case law. It was CIS. I
Yeah.
included the citation in the slideshow, but this is the process for CIS admitting FAS migrants. They can get an E form, they can request a physical form, or they also get a notation on their passport which has no exit date, like it would for a normal visa holder or non-citizen entering. And this was Randy's baby.
yeah.
So I think Randy might want to chime in.
Randy, chime in on this one.
Mr. Cullen? Okay, so just so I'm clear, a green card holder and a COFA migrant cannot get a firearms ID.
Right.
Just a comment, we're mentioning specific forms which may change regularly through the process and federal process. Do we want to say or equivalent? So CPB I-94 form. or
Yeah, I mean,
equivalent?
that's a good point. I mean, that is a good point. Or, yeah, what is the statutes usually say, it's not so much equivalent, they always go facsimile. There's a language for trying to, maybe equivalent is the equivalent form of documentation.
Comparable.
Yeah.
Yeah, but you're right, I think we should add that in there. Because when you specify a form, we know forms
that's it,
change.
yeah.
And that's it, you'll never be able to.
Yeah, so you'll have Form I-551 and then CPBI 94. And I mean, I'm not gonna speak before the inauguration, but I imagine a lot of this will be
Change.
subject to change.
Yeah, so I think we do need some kind of general, I mean, what are these forms? They're basically, documentation that establishes that, right? So I think you're saying, the equivalent document, documentation,
Right,
right?
right.
Okay.
Randy, are you listening to the discussion?
I am, yeah, and because what happened was the statute used to read you had to be a US citizen. Then
Right.
they changed it after somebody realized it had violated all the Supreme Court decisions on people's rights to bear arms, and if they were lawfully within the United States, they added the language about the Immigration and Nationality Act. But the COFA citizens don't come in as lawfully and immigrants. They're not classified as that, but they're still within the United States legally, and therefore they're legally allowed to carry firearms and get an ID. But we just wanted to put this in there so that the statute is not unconstitutional as it applies to them.
Right. But Joe is suggesting though that under the proof amendment provision, that we also have a default or a catch-all document or equivalent documentation or
Yeah, I mean, yeah, that'd be fine, because I mean, basically, I talked to some of the immigration lawyers, when I was trying to figure this out, and they said, yeah, they just come in, and if they come from the COFA district, they just let them in, and they're allowed to live here.
Right. So that's what I'm saying. We just have that. We just add that general or equivalent documentation. I mean, that's pretty
Sure.
That covers it, right? Would you not agree?
I'm gonna suggest that this be tabled for you guys to just
Oh
Give
yeah,
us
we
the
can
language.
we can table it and clean
give
it
us the
up.
language, because.
Yeah, and give you the language. Yeah, we can table this one. That's okay.
Alright.
We'll come up with something like equivalent documentation or whatever, or the proper whatever the phrase should be.
I don't think anybody's objected to the concept.
The concept, right?
It's just the,
Choosing the correct language, yeah.
okay, so if I'm gonna proceed here, the new motion is gonna be to accept the recommended amendment on 69.40. The repeal and reenactment moving of 69.45, 69.50, 69.55, and 69.60. Is there a motion?
I'm gonna object to the shortening of the statute of limitations
On the antitrust.
Okay,
on the antitrust statute.
I also join in that objection.
it's two. All right, any other objections before we second this motion? Is there a second? Second. All right, so we have an objection on the statute, shortening the statute of limitations. And that was Mr. Tennyson, correct?
Right.
Correct.
Any other objections? Okay. All opposed to the motion to transmit those sections, all of it, to the final reading file? There's two, correct?
Yes.
Yeah, just
Right.
two.
It does not carry, it just moves to the final reading file. Thank you. I believe.
I think
Thank you,
that's
Mr.
it.
Tenenko. Thank you,
That's it.
Mr. Tillman. Thank you, Mr. Brennan. Thank you, McDowell, for the work. All right. At this point. The next plenary meeting is scheduled for Thursday, February 6th. February 6th at noon. I have no, in reference to agenda item 7, I have no communication to present. And does anyone have any comments to make in reference to section? There being none, I have a motion to adjourn.
Well, one comment.
Yes.
We had requested, I think, the legislature to give us
I don't know what happened to that. Give us more time and some money and things. I don't think I personally ever heard back what transpired.
I can address that. Monty. At the last budget cycle, we requested an additional year's funding, which we were granted and we're very thankful for.
Which is now covering Mr. Anderson, Attorney Anderson and. Okay, then we repurchased.
And we also requested an additional 2 years to finish all of the work of the commission. If you recall, the original legislation gave us only 2 years to complete the entire project, which we quickly found was going to be impossible. So it gave us another 2 years, and so we should be able to finish.
We will finish.
We will finish. On the 4-year anniversary of our initial meeting date, which would take us into January of 2027.
Okay. And in no small part, your impassioned testimony was a large part of getting us that.
Thank you, Monty.
Because the rest of us were talking.
Thank you, Monty.
The rest of us lawyers were talking in circles in legalese, as we were speaking English. And they got it. They understood.
Has there been any thought or discussion to making it a permanent commission like they do with other judicial?
There's been some internal talk.
Can you not do that, please?
Well, I mean, the laws change.
My
I'm
hair
probably
is
the
turning gray.
only one here who's got a fear factor, and maybe because I sit in a completely different part of Guam with a different industry, but I fear going the 4 years, 2027, and the legislation doesn't pass it. Basically, we spun our wheels. I think it's worthwhile to get Senator Blas in here and say, we need to do an amendment and accept what we've done so far that's passed muster. And so we feel like we've accomplished something, what the goals that you're after, and then we'll continue on with the rest 50%, whatever we got left in the next 2 years. But we got commission members that are really they may not be, but I'm just thinking they might want to drop off the commission because they don't know if the work is gonna pan out
So-
or not, you know.
We're almost completed with 9, and we can entertain that. We're almost done with 9. So we can entertain that suggestion to complete 9, move it to the final reading, but we'll vote on it as a plenary, and then we can forward 9 to the legislature and say, okay, here you go, we're gonna work on 8, and let them have it, so they can move forward with what you wanna do. They can add it.
Well, please correct me if
No,
I'm just all
I think
mistaken.
it's a
but
great
I'd like to say,
suggestion.
Okay, you moved it through, now we feel like,
We got something. done.
wow,
It's a
you know,
great
this really
suggestion.
worked.
We got something done.
Because
No,
right now, to
good
me,
idea.
it's Senator Blas' vision. We, twice, I remember, when we were supposed to have the legislature hearing. Sitting here, listening to it, or we were supposed to be over there, doing similar. And the last time, they said, well, they're having a hearing. And nobody showed up. So I went over I left here, I went over to the hearing, and there was a senator. A
One.
senator having a hearing. So where's the other 14 that couldn't find time to come over? I felt disrespected. For you folks, this is your profession, you know.
So we can entertain that. It's a good suggestion.
It's a good suggestion.
If we finish 9, when we finish 9, we can move it and vote on the final reading file for 9, and then move that to them,
Yeah,
and then we just deal with 8, and we're finished. Good work, good idea.
good suggestion.
All right.
Well, that's what I know.
Yeah.
Any other comments? Any other comments?
No.
Is there a motion to adjourn?
Motion to adjourn.
Second?
Second.
All in favor?
I have.
Nice.
Thank you all for your work.
Thank you.
Maria, see you.
Thank you.
Thanks again, Monty.
Okay, work on
We haven't
board.
done it.
You got work.
Yeah.